That was so much fun. Let's do it again.
I'm still Stacy Blaine. I'm still here on behalf of the bank and Bank of America Community Development.
Let me cut to the chase.
Can I, before you start, can I reserve 5 minutes of my time for rebuttal? Thank you.
Sorry, Ms. White.
Sorry, Jerry.
Assume for the purposes of this discussion that we might find a ground to reverse at least something in the merits judgment. What do we do procedurally with this case? Do we abate it, relinquish jurisdiction, hold it in abeyance without relinquishing jurisdiction? Do we dismiss it as moot?
Well, I think I have to say it depends on what you do. Because I think that the issue is not moot,
Well,
so long as
obviously,
there's something that's still, you know, a judgment in favor of,
Part of the reason I leapfrog to the end of this is, I think the argument, you've both done a great job of briefing your respective positions on, is it all about money, et cetera, and I could ask a lot of questions about those things to sort of flesh them out, but at the end of the day, what we do in the merits appeal, if we affirm, obviously, we have to confront the merits of the propriety of the trial court's ruling on the proposal for settlement. But if we disagree with you on a complete affirmance, we do have a little bit of a quandary from a procedural standpoint as to what to do with this case, because I don't think we can decide it on the merits.
I think it depends on what you do. Because if Bank of America retains some victory, then it's possible the court will be able to reach the conclusion that it was a party who secured a judgment and it beat the offer of judgment.
So
And
just
so-
assume, let's say Bank of America gets to go back and defend all of these claims.
Then that's a different scenario. But I guess that's why I qualified it by saying if Bank of America retains some,
I don't think I understand the distinction.
so let's say you
We
don't
send
reverse
back
on
the-
everything.
If we send back the half of the claims, right?
Right. Then-
What difference does it make?
Well, it depends on what, you know, what their judgment ultimately is. But the question before this court is not then whether you beat the offer, but it's just in any subsequent proceeding, can you ever have a claim for fees under the offer of judgment statute because there was a declaratory
So,
judgment?
again, I'm sorry to jump around with you, but moving to the costs, your counsel's already Berkeley's counsel has already pretty persuasively that that's waived. And the reason being that, you know, you move for fees and costs, you go to a hearing, the transcript of the hearing, the word cost is not uttered. The order on the motion, the only place that cost is in there is in the title, and that's because it carries over the motion. I think that this order issued before the rule was amended to require a 1.53 motion in this circumstance, that Pensacola Beach and the other cases like it are pretty clear that when you have a judgment that you're treating it as final, I understand why, but on the face of it, there's a deficiency, there's no ruling on the costs, there's no denial of the cost motion.
So I disagree with that. I mean, the court denied the motion in total. Now, we didn't explain all of the grounds for the denial. And if every time a court denies a motion in total, but does not specifically explain that the court is denying every ground and mentioning it, I mean, we are going to have a lot of rehearing motions, and I do not think that's what the rule requires. Here, the order denied, it was a single motion for cost under 5741, as well as under the offer of judgment statute, and the court denied the motion in its entirety.
So you're going to hang your hat, I think, entirely on paragraph 1 of that order that says motion is denied.
Correct.
Yeah.
Correct. And then the question becomes, okay, is that never going to be enough anymore? Is every trial court now going to say, it's not enough for me to say the motion is denied. I then have to go through every argument that was made to me and explain this one's denied, this one's also denied, this one's also denied, even though I've denied the entire motion. So I think that that's where, you know, that's what the preservation argument is about. And I don't think I do not think it was a requirement to file a rehearing motion to go in and ask the court. Just wanted to confirm, even though you denied the motion, you meant to deny it on every ground.
I mean, this isn't a subjective analysis like the validity of the proposal for settlement. This is a statutory mandate.
But only if you don't have a ruling. But here we have a ruling. We just don't have an explanation. And so I don't think there was a statutory mandate to file a motion for rehearing because I think we had the ruling. So to go back and talk just briefly about the declaratory judgment action and the effect that it has on this case. It's interesting to me because, I think at the outset, the trial court lacked subject matter jurisdiction to hear the declaratory judgment action. There was no live controversy. The court noted it in its order.
That's not a want of subject matter jurisdiction, that's just, there's no cause of action.
It is subject matter jurisdiction.
It shouldn't be.
I'd say that about a lot of things in the law, but in fact, if there is no actual or live controversy, then the court lacks subject matter jurisdiction to enter.
You have entities that are both based in Florida. There is a request for a declaration. Whether or not the declaration is right, moot, what have you, is something for the court to consider. But it can't get there without taking subject matter jurisdiction of the case to decide it.
But, I mean, courts always have jurisdiction to decide whether or not they have jurisdiction,
Yeah.
but
But that's not what it's doing. What it's doing is it's considering the claim. It's not considering whether it has some jurisdiction. It's just saying, do we really have a controversy here?
it's saying, I don't have the power, I don't have the jurisdiction to resolve a conflict that doesn't exist. There is no live controversy for me to decide, and so I have no
I think
jurisdiction.
that's just another way of saying that it's not a viable claim, which is different than whether or not a court has adjudicated power to make that determination. Those are two separate, that's a rabbit hole. I'm not sure it even plays out here because here, there's no issue of timing of raising the issue.
No,
Yeah.
but the thing that makes it important is, there's some case law out there saying, and this is what's just, going back, this is why it shouldn't be this way, is that if a plaintiff includes a declaratory judgment cause of action, then they have insulated themselves from any potential for fees under the statute.
That came through y'all's briefing loud and clear, and I guess the response to that is call your legislator. Have them change the offer of judgment statute to include claims of equity, and wrap them all up together in the offer of judgment statute. They haven't, because heaven knows this is not the first time this issue has come up and been litigated about, dang it, they're bringing in a deck action, they're bringing in a specific performance count or what have you, and it's gumming up my ability to try to get them on the hook for fees for the 10 other counts that are all seeking money damages.
But the courts have not hesitated to work around, the statute, and we see that for the true relief exception.
Tell me, Javelana is not your best case.
I'm sorry,
Javelana is your best case.
it is one of the best cases, yes.
Is there one that you would have to look to as better than Javelana, from your point?
Or is it like picking your favorite kid? You don't want
I like this court's decision from Polk County versus Highlands in the Woods.
But I think that was factually a little bit off, or less compelling than Javelana, but let me go to the other point here, which is the good faith. I
Okay,
made a $1,000 offer in what looks to me like a gazillion-dollar dispute, at least multiple millions. And I think your argument, reduced to simple terms, is right, because we didn't think we had any exposure, and it turned out to be right. So that's good enough.
and it's a little bit broader than that, but essentially the standard for measure, first of all, it's the offeree's burden to prove a lack of good faith, not the offerer's burden
And
to
since
prove.
we didn't really deal with that, and we had to step up on the burden, because we all were both briefing this sort of prophylactically, I think.
Essentially, I think there was some argument about it at the hearing, but there were no
The
allegations.
trial
of
judge, I
that.
think, expressly said I don't have to go there.
Yeah.
Because I'm
That's
discussing of this on point one, but we could disagree with him on
That's
that, and we would need to look at this.
And so I guess, turning Berkeley's argument back on it, it says that you can't apply the tipsy coachman doctrine when the court hasn't made necessary findings of fact. Not sure I entirely agree with that, but that's the argument that they've raised with respect to the intra-corporate conspiracy doctrine argument that the bank raised. And so I guess the first thing that I would say about it is, the court would have to decide whether the trial court was required to make factual determinations with respect to the good faith evidence, and whether failure to do
I
that.
think this is where Judge Lucas got the alter ego piece from, because I think the argument you made in your brief was the bank had a reasonable basis to believe in its minimal exposure. It's not Tempo's alter ego, and nobody ever alleged that. That was part of the argument that you made in the briefing, if I'm not mistaken. And it had no, what we've already talked about on the merits.
I think it's important to note that the offer of judgment came 3 years after the case had been filed. There have been various, the tortious interference and conspiracy claims were already gone. They had been dismissed, and there have been 20 depositions taken. And so this was not a knee-jerk, let's send them $1,000 offer. I mean, this was the result of some careful and diligent study and analysis based on the discovery that had occurred and what the trial court had already done. And so the fact that it was, what Berkeley calls a nominal offer doesn't matter. I mean, the amount of the offer doesn't matter. What matters is whether the bank had a reasonable but subjective belief that the offer tracked its potential for liability, and it did, and it was right.
Is there some tension between this good faith offer / nominal offer requirement in the text of 768.79? Because there's nothing in 768.79 that prohibits nominal offers of judgment, at least not from my reading. I'm not even sure that there's anything that requires good faith. This is a court created doctrine that we all have to now work with.
Right.
Correct?
Right. Which, no one had to go to the legislature for that one. But, I think I just don't think there is any evidence here that was presented by Berkeley that the offers were not the result of careful
There
study.
was no reason to go there because the trial judge foreclosed it. So I think the whole discussion of burden is precipitous. But it's understandable, and we appreciate getting the briefing on it, because it's something I think we have to look at least in completing the analysis, assuming we don't see some other resolution here based on the resolution.
Right, certainly it would be a fallback argument, I think, if the court were inclined
Yes,
to.
this is probably around trail. You reminded us of the timing that the offer was made. When the offer was made, were we relative to the stipulation on declaratory judgment?
I do not think it had occurred yet, although I'm not going to be wrong about that.
Maybe you're on the policy number.
I think that there had been, the court noted in its order that the bank had, maintained from the very get-go that it was seeking no relief under the rider. And so, and I think the evidence was that Berkeley had known that since at least 2017. And so there was no, thought that the declaratory judgment action was live and was disputed in any meaningful way, because the bank had never made any secret of the fact that it was asserting no rights under the rider. And so the declaratory judgment action was dead on arrival. I mean, the reason it went away is because the bank said, we have been telling you over and over, we have no interest in pursuing any relief against Berkeley under the rider. We're not going to, we haven't. And so essentially what Berkeley was saying, and this is why I think the true relief here is really a relief related to damages, is that Berkeley's theory on the declaratory judgment is yeah, but we filed it as a defensive move. We want to make sure that you're not going to come back later and say that you're entitled to damages against us under the rider, which you can then offset against the damages that we're entitled to collect for the breach of contract. That's why the declaratory judgment action is really a claim for the true relief is a claim for damages. There is no independent value. It was all about the offset that a claim under the rider could generate with respect to Berkeley's breach of contract claim. I will reserve the rest of my time for rebuttal. Thank you.
5 minutes to go.
Again,
Good morning.
CC Brogan on behalf of Berkeley Insurance Company, FMLE here. I'll jump in where you started, Judge Lippert, asking about what you would do procedurally if you were inclined to reverse on the merits. And I've given that a lot of thought while I've been sitting over there, and I don't have a great answer at the moment, but I didn't want to leave the question unanswered, and I wanted to offer that perhaps that's something we could brief if that's something you all needed further. I think Ms. Blank might be right. I'm not sure that it would be moved depending on what you did, especially with the declaratory judgment disposed of, but it could also certainly create quite a mess. So probably, and I apologize for not thinking about that before arriving today, but I'd be happy to answer that question in writing separately if you'd like us to. On the cost issue that you were asking about, the bank mentions that the order denied everything. It doesn't matter if it was silent, but it was plain if it's a prevailing party cost issue, and then that's a pretty basic error in theory. And if it's not there and you don't tell the trial court that you made this error, then you need to tell them you waived it. But in any event, if you all were not inclined, if you rather were inclined to reverse on the cost issue, you would still need to remand it because we have apportionment issues and all sorts of things that would happen in the trial court. On the jurisdictional issue that was raised about whether there was jurisdiction, the trial court had jurisdiction. That is a complete non-starter for some of the issues, reasons that I think some of your questions were getting at, Judge Lucas, but also the trial court thought it had jurisdiction, it resolved the claim, nobody's appealed it, so it's settled. And it was not even pointed out as an issue until the reply brief, which is also not.
Well, in theory, you can write subject matter jurisdiction anytime.
Well, that's fair. Although,
Which may be why it's getting wedged into that way.
perhaps true. But it certainly is not brief. We don't have any type of case law discussion on it in any event. It wasn't appealed, so it's dead and gone.
Let's talk about the elephant here,
Yeah.
which is the debt relief, right?
Mm-hmm.
Your argument necessarily is that the declaratory relief claim had independent value because it cut off the bank's ability to go after you on the bond. But doesn't the trial court's ruling in that regard, it operates to insulate Berkeley from a monetary liability. So one view of this is, it's all about money.
Perhaps, but here's the difference here in this situation. The bank says that that's a restating of the breach of contract claims, but Berkeley's got no breach, we just beat that to death. Berkeley's got no breach of contract claim against the bank. So that's apparently a breach of contract claim Berkeley has against someone else, not the party with whom this deck action, they're engaged in. But even if you try to convert that to monetary relief, here's what's different about this case from Javelana or the Highlands in the Woods case or any of that. Even if you tried to convert it to monetary relief, this would be a declaration about whether Berkeley owes money, whether that's $0 or $10 million or something in between. How much money Berkeley's going to have to pay something else, not how much money Berkeley's going to be getting from somewhere else. And in every single one of those other cases where an equitable claim is found to be true monetary relief, it is always that the deck action gets subsumed within the monetary relief claims because the plaintiff is seeking compensation. In Highland in the Woods, in Javelana, in all of those cases, the plaintiff is seeking compensation, just as Berkeley is here from the bank, but the deck action is also essentially, and I'm certainly paraphrasing here, declare that I have a right to seek compensation against that same party, which is not what we have going on here. Here, we've got Berkeley seeking compensation for the bank from one thing and saying, I have a deck action to make sure that I don't, not just owe the bank, but that I don't have obligations under this, like, it's like an insurance policy. Like when an insurer wants to know what its obligations are under its policy, it's the same thing here. So it is not, I don't think it is a claim for monetary relief. I think it is exactly like an insurer would do. But even if you try to frame it that way, it isn't the same thing because Berkeley's not seeking to recover from the same, it's not between Berkeley and the bank. It's not Berkeley seeking money from the bank. Therefore, Berkeley's debt claim is not being subsumed.
Well, Berkeley was definitely asking to be effectively immunized from liability to the bank on the bond, and they got that.
For sure, but that's not the same thing as Berkeley then seeking to recover against the bank. And therefore, the deck action relief being subsumed within
So,
those
under
plans.
your theory, that's the exact same as a coverage determination for purposes of analyzing true relief.
Yes, yes. Am I gonna tell you it's exactly the same? No, it's not. But is it much closer to that than the alternative where those cases where what's really happening is the question is whether the deck action or equitable relief claim is being subsumed within those other affirmative relief claims? It's definitely not that. And it is much more like the insurance situation. So this is an independent claim. This is not a claim that Berkeley said at the outset, oh, there's no evidence of that. That they were like, oh, let's try to beat this offer of judgment we think might come one day down the road and we'll throw this debt claim in. This is one heck of a case with millions and millions of dollars in dispute. And one way that people are potentially going to be looking to Berkeley, like an insurance company, as a surety company, is under its rider. And it wants to know what's what under that rider and who it's obligated to, if anyone. And Berkeley did actively pursue this claim, by the way. It fought for this claim, and the proposals for settlement were served before the declaratory judgment order. So it did have significant value. Berkeley did want to make sure of its liabilities of any under the bond. And it's independent because, interestingly enough, at the end of the day, whether stipulated or not, Berkeley has relief under this declaratory judgment claim, but it lost on the other claims. I mean, as we just discussed on the merits part of this appeal. So it's absolutely an independent claim, and it is nothing like those other claims. As the board knows, we've also pointed out and argued that this is a nominal, that even if you thought that this was not, even if you thought that this was truly a monetary claim, the declaratory judgment claim, in any event, the offers are nominal. I'm happy to take questions on that. I think that's briefed pretty well between the parties. I know that it is okay to have a nominal offer. It's true that the statute does not have that, but a nominal offer can be okay. Just because you have one doesn't do a proposal for settlement, but you do have to start looking at things like potential exposure, complexity and closeness of the case, whether the claims survive dispositive motions, whether there's a reasonable relationship between the offer and the potential liability. And when the offer here was made, the bank was facing $9 million in liability. Everything had survived motion to dismiss. Heck, down the road, it survived the first round of summary judgment. This is not a nominal offer kind of case, is the bottom line. I think at the end of the day, the trial court reached the right result here on fees and costs, and this court should affirm, but I don't want to leave anything on the table if there are any questions that you'd like me to answer. All right, thank you.
Thank you. Just a couple of points in rebuttal. The first, the subject matter jurisdiction argument, obviously it is not waived. I mean, it can be raised at any time, it can be raised after this appeal is concluded. And so, no waiver there. I think it's interesting too, the declaratory judgment in this action is not remotely like a declaratory judgment action seeking coverage in the case that Berkeley cites. I think the closer question is what would happen in a case where there is a breach of contract for damages for coverage under the policy, and then a declaratory judgment action that essentially says what Berkeley says here, which is we don't have to pay damages because we don't have coverage obligations under the policy. Isn't that just recasting the contract dispute as a declaratory judgment action when the dispute really involves an action for money damages. That is what is at issue here, is a recast declaratory judgment action that seeks a determination that Berkeley's damages can't be reduced by any amounts it might potentially owe to the bank. And so that is an entirely different concept than the case that Berkeley relies on, where there was no damages claim at all in that case. It was merely a contract interpretation case with no damages involved at all. I think it is an entirely different proposition when the declaratory judgment action really just recasts the breach of contract action. There are no further questions. Thank you. Ask the court to reverse the fee motion and affirm on the merits appeal. Thank you.
Well done, some of the best. Great deal.
All rise.